Hello? Hello?
Good morning, sir.
Okay, good morning. Thank you. I was afraid that you guys might not be there by 8 o'clock. Right. So we want to continue with our lectures. And then before we continue today, I want to do a recap of what we did yesterday. A recap, and then that would lead us to, to revocation. Now, yesterday, we highlighted the advantages of using literal rule. And then one of those advantages are that it guards against danger of speculation. It guards against danger of speculation. 2, that it complies with Will's Act, because Will's Act require that wills must be in writing, and that interpreter would have to, kind of confine themselves to what has been written. Number three is that, please hold on. So number 3 is that words always have the same meaning. 3 advantages. It guards against danger of speculation. 2, complies with the act. And 3, that words always have the same meaning. However, these advantages have been criticized on the ground that even the first advantage that talks about guarding against speculation, the antagonists are revealed that if it is viewed very critically, they will find that at the end of the day, that which is considered as advantage is more or less going to lead to guesswork and surmise. Please, I need peace there, please. I'm sorry for the interruption. So the antagonists of the view that even these advantages, if they look at them very well, the very first one that talks about avoiding speculation would lead to what we call guesswork and surmise. Now, the position of the antagonist is that the 3 apparent advantages can be countered. And they say that the first difference between, the first one, which talks about guided against speculation, they said their position is that the difference between the literalist and the intentionalist it's not that the intentionalist is seeking to know what the testator did not express, but that he seeks the meaning given to, the meaning given by the testator to the words that he used. Whereas the literalist seeks the meaning which will be given to those same words by somebody else who is a fictitious ordinary man. So they have countered this first advantage on the ground that the intention of the, the intention of on the ground that the difference that exists between the literalists and the intentionalists is that they are not seeking to know the intention that is not expressed. They are not seeking to know the intention that is not expressed by the testator. But what they are seeking to know is the meaning given by the testator to these words that he has used. Is seeking to know the meaning given to those words as used by the testator. Whereas the literalists are seeking the meaning which will have been given to those words used by the testator by somebody else who is just an ordinary man. So what they're trying to say here in essence is that they should not confuse the purpose of the intentionalist. The intentionalist is not looking for those intentions not expressed by the testator. And that if they compare the position of the intentionalist against that of the literalist, they will find that what the intentionalist is looking for is to find out the meaning given by the testators to the words that he has used, as opposed as against the position of the literalist, who is more or less seeking meaning which will have been given to those words by somebody else who is considered to be a fictitious ordinary man. And on that ground, they are saying that at the end of the day, both literal approach and intentional approach would involve some measure of surmising in the circumstance that they could find themselves, because the two of them, they both involve in what we call gap filling rules of, they both involve gap filling rules of construction. So I repeat myself by saying that they have attacked the first advantage by saying that the advantages that they are talking about will be countered, and that attacking the first advantage, they said that the difference between literalist and the intentionalist is not that the intentionalist is seeking those intentions that are not expressed by the testator. They are not seeking to find the intention not expressed by the testator, but what they seek is to find the meaning given by the testator to the words that he has used. So the intentionalists are looking for the meaning given by the testator to the words that he has used. So now, again, they are now saying that if you put that by the side of the position of the literalist, you find that the literalist is more or less seeking the meaning which will have been given to these words used by the testator by somebody else, or somebody else who is considered to be an ordinary man. And that doing this by the two of them amount to the same thing. It would get to a point that the two of them will be surmising. They will be surmising. And then what that means is that, of course, if we say that either literalist or the intentionalists, if they engage in what they call gap filling, if they engage the gap filling rules of construction, then at the end of the day, the two of them will end up doing guesswork. So now we left that, and then we went to compliance with, we left that and we went to compliance with the act. Now, the literary second point is that, as far as they are concerned, the intentionalist is saying that the literary second point is misconceived, because Will's act only, kind of require that will should be in writing. It did not indicate how writing should be interpreted or will be interpreted. Of course, they went further to say that in the 19th century, judges go as far as to say that words have a correct meaning. But they have attacked this on the ground that words again, when we look at them, their meaning, how do I put it? Words gain their meaning from different ways in which they are used. They may not necessarily have this correct meaning that judges are talking about in the 19th century, because they said, as far as they are concerned, words gain their meaning from the way in which they are used. That different people in different groups at different time and different places, they use words very differently. So now, still more or less, countering the advantages that the literalists brought out of the fact that, out of the fact that literal rule of interpretation complies with research, they are saying that literalists have misconceived this position because Wills Act only requires that a will be made in writing, and without indicating how this writing is to be interpreted, and that all the position of the judges of the 19th century saying that words have a correct meaning may not be correct because words gain their meaning from the way in which they are used. Words gain their meaning from the ways in which they are used. So the position of the judges in the 19th century may not be correct because words gain their meaning in the way they are used. And that to that extent, they have justified that different people in different groups at different times and at different places have used words so differently. So the position of the intentionalists is that the literalists do not usually refer to correct English words. They do not really refer to correct English. But what they claim to interpret, they claim to interpret words in a will as though they had been written in ordinary and normal English. So now they still go further to use this to counter the position of the judges that words have correct meaning. And that in countering this, they said words gain their meaning from the way they have been used, because people use words in different groups, in different times, and at different places, and of course they are used differently. However, they still went further to attack the literalists to say what the literalists do is not necessary to refer to correct English, but what they do is trying to claim to interpret words in the will as though they have been written in ordinary or normal English. Of course, they went further to say that it is better for us, or rather it is instructive for us, to consider again the original hypothetical example that we have suggested at the beginning of the chapter, where someone makes a homemade will leaving property to my nephew and nieces. Of course, the lawyer's interpretation of the phrase nephews and nieces will probably be blood nephews and nieces. But there is a looser popular meaning which will include nephews and nieces by marriage. And this further goes to show us that it depends. The use to which you put the word is the meaning that it's going to have. I go further again, or rather I go back again to say they have attacked the position of the literalists by saying that they have misconceived this position they have stated that that it complies with the Wills Act Wills Act provision, because to them they are saying that though wills require that Wills Act requires that wills must be in writing, it has not indicated for us how it's going to be interpreted, how the writing is going to be interpreted, and that the position of the 19th century judges that words have a correct meaning may not be correct. And to that extent, you can see the case of Lowe and Thomas, where it was further mentioned that words gain their meaning from the way in which they have been used or the way they are used. And to illustrate it, we know that different people in different positions, in different groups, and at different times and different places, they use words in different ways. And they went further to say that still in their attempt to attack this position of the literalists, they said literalists don't usually refer to correct English. What they refer to is, or what they try to do, or what they claim to do, is to interpret words in a will as though they had been written in ordinary and normal English, not necessarily seeking correct English, but they are seeking to establish that the words used in a will has been written, though, in a ordinary or normal English. And therefore, to still further counter them, they say it is instructive for us to go again to our original hypothetical example, which suggested that, there was a woman or there's a person who made a homemade will, leaving property to my nephews and nieces. And that if the lawyer will interpret this, the lawyer's interpretation of this phrase, nephews and nieces, will probably be blood nephews and blood nieces. But we cannot be stuck to that, because there's a loser popular meaning, which will include nephews and nieces by marriage. So they're going further to say that if it can be shown that while the testator was alive, he habitually used the expression "my nephews and nieces" to include his nephews and nieces by marriage. So why would you now want to reduce nephews and nieces to only nephews and nieces by blood? Because that's what a lawyer would do. That is what would be the meaning that lawyers will give to it. So they are telling us that they are telling us that naturally what the lawyers do is that they try to look at the word in the way that it should normally be, ordinarily it should be, but certainly that is not the position many times, because looking at it the way it should normally be, or the way it should ordinarily be, may not represent the true position, because you find that words would be used differently at different times and at different places by different persons. And that, of course, in our example, if the lawyers will interpret it, they'll practically say that it refers to nephews and nieces who are blood related, but there's a loser sense, which is even more popular, which will require that nieces and nephews who are related by marriage are part of the people that we're talking about. And therefore, we went further to say that, should we now give the lawyer's meaning to nephews and nieces if, when the testator was alive, he has used that expression, nephews and nieces, to include nephews and nieces by marriage? And therefore, that is one of the grounds by which they are saying that we should not follow literal interpretation to deal with construction of a will. The third one also, they mentioned that words always have the same meaning. They say it's also not true. It's also not true that this advantage of the literal approach is to them purchased at a very high price. Of course, the meaning may not be the meaning intended by the testator. Of course, they are now saying that given because if you say that they have the same meaning, they are saying that to say that their words have the same meaning is not correct, because the meaning you are giving to it may not be the meaning that the testator has intended. It may not be the meaning that he has, and it has shown from the above example that if you say that they have the same meaning, it may not be correct. Now, if you say they have the same meaning, to say nephews and nieces, and lawyers will interpret them to mean nephews and nieces to nephews and nieces who are related by blood. But the man, when he was alive, he has referred and intended to cover nephews and nieces up to nephews and nieces that are related by marriage. So if you restrict the word nephews and nieces in his will to merely nephews and nieces who are related by blood, on the ground that words have the same meaning, then you have not interpreted the will very properly. It then means that you will be doing injustice to that will or the interpretation of that will, because they are saying that it is wrong, totally wrong, for you to say that words have the same meaning. The meaning you are giving to it may not be the meaning intended by the testator. If you go by that rule, Of course, the nephews and nieces would naturally suggest to lawyers that it is nephews and nieces that are blood related. But if when the man was alive, his own notion, his own meaning of nephews and nieces, the extent to nephews and nieces by marriage, then of course you have not given the right interpretation to that word that have been used by the testator. Of course, they say that given that virtually all construction problems arise because the literal meaning and the meaning the testator intend to have, they differ. They differ. It would naturally differ because if the man actually is thinking that I have nothing that is covered by marriage, and then the lawyer's interpretation is that it has to be nephews and nieces by blood because words have the same meaning, then problem of construction will arise. So it goes further to tell us that it follows that in all cases, the literal meaning is not what the testator intended. It's not usually what the testator have intended. So please note this very importantly, that those lawyers' meaning attached to a word may not be what the testator will intend, and therefore it will be wrong for us under the rule of construction to assume that words have the same meaning, or that words have the same meaning, or that compliance with the act means that literal will have upper hand over the intentionalist. So I'm not sure whether I'm making any points. Hello, guys. Are we there? Hello.
Yes, sir. Yes, sir. Good morning, sir.
Yes, sir.
Good morning.
Yes, sir.
Did I communicate?
Yes, sir. Yes, sir. Yes, sir.
Yes, sir.
Okay. So now we move on to the advantages of intentional approach. We move on to advantage of intentional approach. Now, the first one is that they are saying that they look at the first advantage of intentional approach is simplicity. Now, the principal advantage of intentional approach is that it is much simpler to operate. Of course, they said there is no need for technical rules concerning non-admissibility of certain type of evidence. Now, 2, there's also no need for detailed learning about the technical meaning of words, because what the man is looking for is the intention of the testator. Also, remember that in seeking the intention of the testator, they probably will call extrinsic value and extrinsic evidence to establish what is the intention of the man. Of course, what that means is that they have knocked out the technical rules concerning non-admissibility of certain types of evidence. There's also no need for detailed learning about technical meaning of words. So these are the 2 advantages that simplicity will confer on the intentional approach, that those technical rules about evidence is done away with. Then those technical learning about, detailed learning about technical words is also done away with. So that's why we are saying that, it is more or less offering simplicity, and it confers an advantage on the intentional approach. Of course, they said the readers of a will is entitled to assume that when a testator uses a word, it generally means them, it generally means by them what others would mean by them. So what he's saying is that if you read a will, of course, it is possible to us to assume that the meaning that we give to it is the meaning that other people will give to it. But what should also cross our mind is that what should also cross our mind is that he generally, he also is entitled to assume that the testator has used these technical terms, very accurately to reflect what he has in mind. So what I'm trying to say in essence is that the simplicity one is conferred on, intentional approach because the technical rules about admissibility or non-admissibility of certain types of evidence is done away with. 2, there is no need for deeper learning about the technical words or meaning of technical words And also, they're saying that the intentional approach is such that when a word is seen in a will, it is possible to assume that it is neither here nor there. You could assume that the meaning that testator has given to it is the same meaning that other people are giving to it. And you could assume otherwise. That's why they are saying that it is more or less, offering simplicity and is an advantage that is more or less in favor of intentional approach. But they are saying that when you say that you can assume that the way he has used it is the way other people have used it, and that it could be other way around, they are subject to evidence to the contrary. They are subject to what? Evidence to the contrary. If evidence to the contrary is established to show that it is not the way we have interpreted to be, then it will be jettisoned. Our interpretation will be jettisoned. So, summary of simplicity is that one, it does away with technical rules concerning the non-admissibility of certain types of evidence, and that there is no need for detailed learning about the technical meaning of a particular word, and therefore it makes it possible for anybody who's reading the will with the mindset that he has an intentional approach to assume that the testator has used that particular word in the way other people have used it. He also could assume that he could have used it in another way, and it's very correct the way he has used it. But all of this is subject to contrary evidence, which may be adduced to shift the position. That having been said, we are not talking about another advantage of the advantage of what is it called? The advantage of intentional approach. The second advantage of the intentional approach is that it gives maximum effect to the express wishes of the deceased. Remember that advantages that we mentioned here include simplicity and giving maximum effect to the express wishes of the deceased. So I take you back so that we can put our thoughts together. The first advantage of literal approach is that it gets against danger of speculation, and then it complies with Will's Act, and that the words always have the same meaning. But it has been criticized on the ground that what they refer to as advantage of guiding against speculation will result into guesswork and summers. It has been further said that compliance with the Act does not confer any advantage, and it has been misconceived, because compliance with the Act only requires that wills should be in writing without necessarily telling us, how those writing will be interpreted. And therefore, even though judges' assumption that words have correct meaning may not be correct, because words have their meaning from the way they are used. And that oftentimes you find that different people in different settings, in different groups, in different localities, they have at different times and different places use the word very differently. And therefore, they went further to tell us that the literalists do not refer to the correct, they don't refer to the correct English. What they seem to do, or what they claim to do, is to interpret words in a will as though they have been written in the ordinary or the normal English. Of course, they say that we should go back to our example that we started, and then consider the hypothetical example that we started, where we mentioned that there was, an homemade will that the testator actually left property to nephew and nieces, and that, of course, if you look at that word, nephew and nieces, in that thing, the lawyer's interpretation, going by literal rule of interpretation that they often adapt, is to say that nephews and nieces are probably by blood, and that they are forgetting that there could be a looser, more popular meaning, which will include nephews and nieces by marriage, and that they now pose a query that, assuming that when the testator was alive, he has habitually used the word, nephews and nieces, to include nephews and nieces by marriage, then where is the logic? What is the logic in restraining, in saying that what is the logic now in restricting that word to lawyers' meaning, which says that it has to be nephews and nieces who are related by blood? We had gone to saying that words may not necessarily have the same meaning. They may not necessarily have meaning. And the difference between these two group of people, is that one is even though literalist is seeking to get the intention of the testator is not seeking, sorry, I'm coming. No, it's not. It's what I'm saying that when there is a problem about construction, when there is a problem of construction, words may not necessarily have the same meaning, and it flows from the example that we are giving. It flows from the example that we are giving. When you say that somebody said nephews and nieces, if you give it lawyer's meaning, it may not have the same meaning with what the testator is looking for. If he's an African man, he will see a child. He will see a child of his brother as his own child. He will see the child of his sister as his own brother. But it is not so. If a lawyer will interpret it, advantages of the international approach is that it gives simplicity because it doesn't make us have to confine. It doesn't have to confine us to technical rules concerning the non-admissibility or admissibility of certain types of evidence. And there is also no need for us to have deeper knowledge of what are the technical meaning of words. And he goes further to say that it may be right for us to say that when we look at the words used by the testator in the will, he uses it in the way other people have used it, or it is also possible to assume that he has used it differently, and then, of course, it will be assumed that he has used it so accurately. But in all of this, we should bear in mind that all of this interpretation we are talking about, which is conferred by simplicity, which is conferred by intentional approach, will be subject to contrary evidence. And I said that the second advantage, which gives, which flows from intentional approach, is that it gives maximum effect to the express wishes of the deceased. It gives maximum effect to the express, wishes of the deceased. Of course, they said, if you look at it in the recent year, statutory interpretation has become more purposive. Statutory interpretation has become more purposive. Are we together? And that, less literal in the attempt to give effect to presumed intentions of legislators. So what we're trying to say, even the legislators have become more purposive and less literal in their attempt to give, effect to presumed intentions of the legislators. So don't forget the main point. The main point that is that intentional approach gives maximum effect to the express wishes of the testator, and that in the recent year, statutory interpretation has become more purposive and less literal in the attempt to give effect to the presumed intentions of the legislator. You can see the case of Pepe and Hart. Pepe is spelled P-E-P-P-E-R. Hart is spelled H-A-R-T. Now, that having been said, you need to note also that when we interpret statute, there are reasons for adopting literal approach, apart from this position, apart from the fact that they are even moving from purposive, they are moving from literal to purposive. You even find that when you even interpret, statute, there are reasons for adopting literal approach, which does not apply when will is being interpreted. There are reasons to interpret, apart from the fact that, besides the fact that, people are moving, or that the system is moving more towards purposive approach than, literal approach, of course, in an attempt to give effect to the presumed intention of the legislator. In fact, look at it more critically. You'll find that they say that when interpreting statute, there are reasons for adopting the literal approach, which does not apply when interpreting will. Of course, the literal interpretation of a statute will protect the reliance of citizen upon it, protect the reliance of the citizen upon it, whereas there is no equivalent reliance by a beneficiary or who will be beneficiary on the wording of a will. So these are the points that you need to bear in mind, that even the so-called people who interpret statute, they are moving towards propositorship so that they will do what? They will be able to achieve or give effect to the presumed intentions of the legislators. They will move forward to purposive approach to be able to give effect to the presumed intentions of legislators. So that having been said, I need to also mention to you that the learned author also went further to tell us that House of Lords at some point had actually abandoned what we call liberalism. Please follow me. And that is, if you read the case of Perrin and Morgan. Perrin and Morgan, of course, the problem, there's a part, if you check the case of Perrin and Morgan and you follow me, you find that at some point, the Perrin and Morgan, more or less, is a case where the court actually abandoned literal rule of interpretation. Please take time to follow me, and then we'll get there. So, hello, hello, hello,
hello, sir. Hello, sir.
Are you the only one in the class?
No, we are following, sir. We are following, sir.
Okay, 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 okay. Yes, I just wanted to be sure that I'm communicating. Hello? Hello?
You are, sir.
Hello?
You are, sir.
Hi, sir.
We can hear you, sir.
Okay, thank you very much. Okay, now, we had itemized the advantages. We had itemized the advantages. We had itemized the advantages of... Hello? Hello?
Perry and Morgan.
Hello?
So I was asking the case that you mentioned, sir.
Yes, I said we will get there. I'm mentioning Perrin and Morgan.
Can you hear me?
Yes, I can hear you. Perrin and Morgan. Perrin is spelled P-E-R-R-I-N against Morgan, M-O-R-G-A-N. Hello?
Okay, thank you, sir. Thank you, sir.
But really, if you are not compelled in any way, I'm not compelling you. If you have the money, if it's convenient for you, if it's possible, I advise you to get this book, The Law of Succession, revised edition, The Law of Succession in Nigeria, Principle, Cases, and Practice, by no other person, Professor, Babatunde Adetunji Oni, SCN, and the HOD is presently the HOD of the Department of Private and Property Law. I am not compelling you. I only advise you that if you have the money. Hello? Hello?
Both of us have it.
Sir, we have it, sir.
Okay, no problem.
We have it,
No
sir.
problem.
We have it, sir. Yes.
Okay, no problem. So if you have the means, you can get it. If it's not possible, just follow the lecture. You'll be fine also. But it will give it also form part of your library, such that even when you leave law school, you can still use it. So now we have explained, the advantages, the criticism of the advantages of literal rule. We have gone beyond advantages of intentional approach. We're now saying that even at some point, the House of Lords had actually, abandoned literalism. They abandoned the literal approach. And just follow me, and I will explain to you. He said a particular problem with literal approach was that lawyers who talked about giving words their ordinary meaning seem sometimes not to realize that what they were really doing was to give them a lawyer's meaning. The meaning the words would have had if they were being used by lawyer. So when lawyers say that, they give a word an ordinary meaning, it then means that they are just giving it lawyer's meaning. That is the meaning which they will have had if it has been interpreted or if it has been used by a lawyer. So, no, but to give words, in homemade will, the meaning they would have had if they had been used by a lawyer was not easy to justify. It couldn't have been easy for them to justify that a homemade will have the meaning, a word in a homemade will have the meaning that will have been given to it if it is used by a lawyer. It's not right. It's not justifiable. So there's a direct challenge to literal approach, as in direct challenge to literal approach was bound to come up. And this came up in the Perrin and Morgan. I repeat myself so that the point can sink, that the particular problem with literal approach was that lawyers who talk about, ordinary meaning seem sometimes not to realize that they were really doing what we call, giving words lawyers' meaning. That is, the meaning the words will have had, the meaning the words will have had if they were being used by lawyers, and therefore to give words that are contained in the words that are contained in a homemade will, lawyers' meaning is it's not going to be easy to justify. It's not going to be easy to justify, and then to bring a direct challenge to literal approach, and this is found in the case of Perrin and Morgan. I'm not sure whether you understood the point I'm making. Did you get the point I'm making? Hello?
Yes, sir.
Hello? Okay, thank you. Now, in that case, a woman died. Please follow me. A woman died, leaving a homemade will. He died leaving a homemade will, which she directed that all monies of which I possess shall be shared by my nephews and nieces now living. Are we together? Are we together?
Yes, sir.
Yes,
okay.
sir.
Now, it goes further. But before we go further, please note that in that will, she said that all my money of which I possess shall be shared by my nephews and nieces now living. However, there are earlier case law that had established that the word money or money meant money in cash, money in the bank, debt owed to the testator, but not residuary personality, not net residuary personality. Of course, some of those cases that have earlier held that money include money in cash, money in bank, and debt owed to the testator, but not net residuary personality, includes the following cases. That I will mention to you here. Number one is the Shellner's case. That is SHELNIER case. Now, another case in that line is Jones and Collins. Jones is spelled JONES against Collins. Collins is spelled COLLINGS. Are we together? Of course, there's one case around that time too, which did not follow that line of thought, which is Lynn and Kerridge. Lynn is spelled LYNN against Kerridge. Kerridge is spelled KERRIDGE. So now we are saying that we're trying to draft to a point where we're going to establish that the House of Lords itself abandoned literalism. And the first point that we mention is that lawyers, when they seek to give word ordinary meaning, they are giving that word only what we call, lawyers' meaning. That is, law, the meaning they will have had if they have been used or interpreted by lawyers. And therefore, to say that homemade wills, which contain some words, will be given ordinary meaning or lawyers' meaning, will be very difficult for anybody to justify. And certainly, it will bring a direct challenge. It will lead to a challenge against the literal rule. And this had actually happened in the case of Perrin and Morgan. I want to come along with me because in that case, the woman died leaving a homemade will in which she has directed that all my money, which I possess, shall be shared by my nephews and nieces, of course, who are living. But they said even before that time, there have been two cases that I mentioned to you, which include Shellner's case and then Jones and Collins, which had interpreted very restrictively money to mean money that is held in cash, money in the bank, and debt owed to the testator, but did not include net residuary personality. Of course, it was also quite clear that in many of these cases, the literal approach had led to a result not intended by the testators. Are we together? Not intended by the testator. So what I'm trying to say is that, of course, this woman at this time, in the case of Perrin and Morgan, had actually left a homemade will in which she had said that all my money, which I possess, shall be shared by my nephews and nieces now living. And at that time, there were cases that had adopted narrow interpretation, literal rule, ordinary meaning, and then they have defined in those cases, money as money that is held in cash, money that is left in the bank and debt owed to the testator, but did not include net residual personality. And the effect of this is that it was so clear that at this time, many cases, when these cases were decided, the literal approach that was adopted in those cases had led to a result not intended by the testator. I'm not sure whether you are getting the point before we move to the next one. Are we together?
Yes, sir.
Did you get that point? Okay, now, so those cases that have been decided earlier that Perry and Morgan had actually led to the application of literal approach, and which has resulted in giving meaning that was not intended by the testator to the words that are used in the will. And now, in Perry and Morgan, the testatrix estate was worth about £30,000 and consisted almost entirely of stocks and shares. If they had interpreted the case, if they had applied the literal rule if they had applied literal rule, which were applied in the earlier cases, like the case of Jones and Collins, so the case of Perry and Morgan, then they will have, the bequest, the bequest would not have gone to the nephews and nieces, because here, most of the shares, most of the things that he had were in stocks and shares, and stocks and shares were not included in definition of money because they gave it literal meaning, literal approach. They gave it ordinary meaning in the earlier cases that we have reviewed, leading to a situation whereby the literal approach had led to a result not intended by the testators. So coming back to the point, we said Perry and Morgan, the testatrix estate was worth more than £30,000 and consisted almost entirely of stocks and shares. She obviously intended the stocks and shares to be passed under the word money, because if they did not, she would die almost wholly intestate. Almost wholly intestate. Of course, the House of the Lord reversed the Court of Appeal decision. They reversed the Court of Appeal division, which had followed the earlier case law. And instead, they gave the word money a wider reading. Because if they had followed the earlier case law, in the case of Perry and Morgan, of course, the woman would have died intestate against her wish. So the Court of Appeal had actually ruled that money does not include stock and shares, but the House of Lords abandoned the literal rule, the literal interpretation that had been applied in the earlier cases. And they did now rule that money would naturally include stocks and shares in trying to give a wider interpretation, a wider reading to what is money. Are we together? Are we together?
Yes,
Hello?
sir.
Yes, sir.
Okay. Okay. So that is notwithstanding that there are line of case laws, as stated in the case of Jones and Collins and Shelnier's case, stating that money would not go beyond cash, money in the bank, and debt owed to the testator, and then would naturally not include residuary personality. Residuary personality has now been included to include those shares and stocks which the woman had. Remember, we said that she had about £30,000 worth of assets, and which are consisted mainly, mainly stock, which consisted mainly of stock and shares. And then obviously she had intended that those shares and stock would pass as money under her homemade will, because if they did not, she would die almost wholly intestate. If they have followed the old cases, if they have followed the old case law, then this woman will have died in what? Intestate. All her effort to make a will will have done what? Will have become a waste if they have applied the literal rule. The literal rule which had been applied before had excluded stock and share from the definition of money. And the House of Lords reversed the decision of the Court of Appeal, who had followed the earlier case law, even though the Court of Appeal too, they followed that earlier case laws very reluctantly. They followed it reluctantly, but the House of Lords gave the word money a wider reading. Of course, the decision was said to be very unanimous. decision was very unanimous, but the result was reached by two different routes. Two different routes. No member of the House of Lords referred to any general theory. They never refer to any general theory. So the point I'm making is that, situations where things will lead to absurdity, literally will lead to absurdity, then judges are expected. They are expected to do what? To apply the intentional rule. They are expected to apply the purposive rule. Of what purpose? What was the measure? What was he intended to achieve? If they had actually followed literal rule in the case of Perrin and Morgan, then it means that the essence of the will would have been wasted. The woman would have died intestate. So now, that having been said, of course, we are saying that the focus was simply on reversing the earlier. This focus was simply on reversing the earlier case law. Are we together? Are we together?
Yes, sir.
Okay. Yeah. Now, so they're not saying that there was a straightforward split between the Chancery lawyers and the non-Chancery lawyers. Straightforward split between the two of them. Of course, the Chancery lawyers, Lord Russell, of Kilowen and then Roma gave. This is just by the side, but the point I've been made. I made the point. It was. He gave a wide interpretation of the word money by finding it in the context of the will. So he supported wide interpretation by saying that the will had to be read as a whole, and that the context showed that the word money in this particular will did not bear the meaning usually given to it. Look at what he said. Russell told us. Of course, he was saying that he has to give this money so defined here. He has to give it a wider interpretation. He found that in this context, or in the context of this will, money in the context of this will has to be given a wider interpretation, because he said that the will had to be read as a whole, and that the context shows that the word money in this particular case, or in this particular will not bear the meaning usually given to it. So if we have said money will be defined the way it has been usually defined, then the woman who made a homemade will in Perrin and Morgan will have died intestate. So if they had used the usual meaning, if they had applied the usual meaning, then it means that naturally the woman will have died intestate. Because look at what Russell said. He said, a wide interpretation of the word has to be given to money by finding it in the context of the will, and by saying that the will had to be read as a whole, and that the context of that will shows that the word money in the particular will did not bear the meaning. The money did not bear the meaning that is usually given to it. The meaning usually given to nephews and nieces by lawyers may not be the meaning that testator is giving it, who is usually in the habit of referring to nephews and nieces who are related by marriage to him, to be part of his nephews and nieces. But if you give it the lawyer's meaning, then the intention of the testator will have been jettisoned, will have been jeopardized. So now what we're saying that, in other words, they were affirming that word money had an ordinary meaning, but that they were not going to adopt it in this particular case. This was the standard way of appearing to follow the literal approach, but escaping from it on the special fact of the case. Remember, we have taught that you should follow literal rule. When you follow literal rule, but when it's leading to the point of absurdity, you should apply purposive approach. And that's what I thought the House of Lords did here. That's what the House of Lords did. They said, in other words, they were affirming that the word money had an ordinary meaning, but that they were not going to adopt it in this particular case, because if they had done so, it will not bear the meaning that the testator or the testatrix has given to it. So they said this was the standard way of appearing, to follow the literal rule, but escape from it on the special fact of the case. the non-chancery lawyers, who is Viscount Simon Elsie and Lord Acton, and then Tarkington, they simply decided that the word money had no strict or primary sense. They had no strict or primary sense. So this is more or less saying that we should, at points that application of literal rule is leading to absurdity, we should abandon it and apply the purposive or the intentional rule. Are we together? Are we together?
Hello? Yes, sir.
Yes, sir.
Okay, so now let me also come to some rudiments that have been listed for us when we are trying to apply, when we are faced with construction of a will, and that according to F.J. Onyekoro in his book, The Wills, Probate Practice and Administration of Estate in Nigeria, in page 30 of his book, he has identified the following Gandhi principles in the construction of a will and codicil, and they include one. Please note, they include one. I'm going to read out to you. It says, one, the whole will must be read, just like Russell has told us. Just like Russell said, he said that the will had to be read as a whole, and that in this concept show that the word meaning in this particular case would not bear the meaning usually given to it. So you have to read the entire will. He said the whole will must be read. That's number one rule that will lead you to a proper and effective construction of a will. Number two, it says that will must be read as to all properties of the testator, as to all properties of the testator. Words in a will should be given a literal meaning. Words in a will should be given a literal meaning. Ambiguous provision in a will are construed by extrinsic evidence. Extrinsic evidence, that's number four. Number five, it goes further to tell us that list of gifts in a will, followed by words with a wide scope, should be construed ex judem generis. List of gifts in a will, followed by words with a wide scope, should be construed ex judem generis. Number six says that beneficiary may be put to elect where is given a legacy and his property given to a third party. 6 points he has mentioned for us, or he has listed for us. Number one, the whole will must be read. Number two, the will must be read as to properties of the testator. Number three, words in a will should be given literal meaning. Number four, ambiguous provision in a will are construed by extrinsic evidence. Number five, list of gifts in a will followed by words with a wide scope should be construed ex judem generis. Now it goes further to say that beneficiary may be put to elect where is given a legacy and his property has been given to a third party. Now, if you check, I would advise you to go and check, some samples of will, so that you'll be able to know how will is written, what are the components, and rest of that. But this would dovetail into, that is the end of construction of a will. We now go to revocation of a will. We go to revocation of a will, and then as a matter of general introduction, a will does not take effect. You know that. We are now on revocation of wills. Now, a will does not take effect until after the death of the testator. Of course, what that means is that it is ambulatory. And then the implication of being ambulatory means that while the testator is still alive, he can revoke, he can amend, he can still alter his will, because the will has the nature of being ambulatory the will is ambulatory in nature. I repeat myself, and I say that generally a will does not take effect. It will not take effect. It doesn't come into operation until after the death of the testator, because it is ambulatory in nature. And the implication of that is that, the testator, when he's still alive, he could revoke the will, he could amend it or alter it. And then he goes on to tell us that revocation, what does it mean? It simply means the recalling of some power, authority. Listen to me. Revocation means what? Recalling of some powers, some authorities, and things granted, or destroying or making void some deed that existed until the act of revocation made it to be void. I repeat myself, revocation simply means the recall of some powers, some authorities, or things granted, or destroying or making void some deed that had existed until the act of revocation made it void. I go back again to our introduction, and I mentioned to you, a will does not take effect until after the death of the testator, and this simply implies that while the testator is still alive, he could revoke, he could amend, he could also alter his will, because of the nature of will, which is very ambulatory, and that revocation simply means that it is a situation whereby we recall some of our powers, some authorities, and things that have been granted, or destroying, or making void some deeds. You destroy or you make void some deed which had existed on the act of revocation made it void. Now it goes further to tell us, or more or less, I want to repeat myself and say that revocation means you recall some authority, you recall some power, you recall some things that have been granted, or you destroy or you make void, some deed that had existed before the revocation made it, before the act of revocation make it to be void. Of course, when we are talking about revocation, your revocation that you are making could either be general, of all the acts or the things done before, or special, or revoke a particular thing. So it could be general, it could relate to a particular thing, and that this must relate to things that have been done before this revocation. And that how can we revoke a will? A will can be revoked in the following ways. One, when a subsequent will or codicil is made. When you make a subsequent will or make a codicil, are we together? When a subsequent will or codicil is made, when you make, other instrument of revocation, it could be by marriage, it could be destruction with intent, it could also be animals revocandi, that is intention to revoke.
Hello, sir.
Yes, sir.
Please, you are a bit fast.
Oh, okay, sorry about that. I'm sorry.
Okay,
I'll go back again. I start from the beginning. I remember that I mentioned to you that will does not take effect until the death of the testator. And what that suggests to us is that while the testator is still alive, after having made a will, it could still, kind of revoke the will. It could amend or it could alter it. This is made possible by the nature of will, which is very ambulatory. Being ambulatory means that it is suspended, its operation is suspended until the death of the testator, until the death of the maker of the will. However, we have defined or tried to describe what revocation would be. Revocation means that it is the recall of some authority, some things that are granted, some power, or possibly the making void or destruction of some deed which had existed until the act of revocation made it to be void. Until the act of they had existed, those power, those grants, those authority which you now remove had existed, until this act of revocation had made it to be void. Of course, we said the revocation we are talking about could either be general, it could be special, it could revoke a particular thing. In fact, it could be in respect of all acts or things that have been done, that are done before that revocation. And as we said that, what are the ways by which we can revoke a will? The first one is subsequent will or codicil. You have made a will before, you now make a subsequent one. The other one is instruments of revocation. Number three is, marriage. So one is subsequent will or codicil. Number two is other instruments of revocation. Number three is by marriage. Number four is by destruction of the will with intent. Destruction of the will with intent. Then number five is animals revocandi, which is intention to revoke. Then number six is dependent relative revocation, and other conditional revocation. So those are the three things I've mentioned in, those are the things I've mentioned in 3 paragraphs. But let us begin to take them one after the other. Number 1, subsequent will or codicil. Subsequent will or codicil. So we begin to look at them one after the other. And the first one we are taking is when you make a subsequent will or codicil. What is the effect? How does it revoke the other thing, or the other wills that have been existing? What must you put there that will lead to effective revocation of the existing will and codicil? Now, usually, when another will is made or a codicil is made, okay, what happens is that expressly or impliedly, if you make it either expressly or impliedly, it will revoke the earlier will. Now, let us look at express revocation. Let us look at express revocation before we come to implied revocation. Now, when we talk about express revocation, now this is done by expressly. So if you make a will, if you make a subsequent will or a codicil, for it to have expressly revoked the existing will, it then means that you can do this by inserting a revocation clause in the subsequent will. Sorry, I'll get back now. Okay, so sorry. Hello? Hello?
Hello?
Okay,
hello, sir.
Revocation could be expressed or could be implied. So let us look at the express revocation. So what I'm saying is that one way by which a will can be revoked is by subsequent will or codicil. And then when you make a subsequent will or a codicil, it is possible for you to revoke your will either expressly or impliedly. And that express revocation is the first to be taken out of the 2 of them. Of course, when we talk about express revocation by subsequent will or codicil, what this means is that we can do this by expressly inserting a revocation clause in the subsequent will. You expressly insert a revocation clause in the subsequent will. Of course, the word that is normally used, the word that's normally used sorry, what I'm trying to say, the word usually used to denote a will as being the last and only will may not themselves revoke the earlier will. Please note that when you want to revoke when you make a subsequent will and you make a subsequent will or a subsequent codicil, you may not be able to have expressly revoked your earlier will if you don't insert an express revocation clause. An express revocation clause. They usually put in, this is my last will, or this is my last testament, will not themselves revoke, using the word my last will or my only will not by themselves revoke the earlier will. The simplest way or the simplest method of revoking a will is by validly executing a further will. And then it says that in section 20 of the Wills Act, it says that the whole part or part of the will may be revoked by another duly executed will or codicil. The clearest manner in which this can be expressly done is by indicating or including a revocation clause in the later will. And what's an example of revocation clause? It says, I revoke. You can say, I revoke all my former will and testamentary dispositions and declare this to be my last will and testaments my will. So what I'm trying to say here in essence is that the very first means by which you can revoke a will is to make a subsequent will or a codicil. When a subsequent will or codicil is made, revocation may take the form of express revocation or implied revocation. When it is express revocation, by virtue of subsequent will or codicil, this is done by expressly inserting a revocation clause in the subsequent will. The word that you use, or more or less denoting that a will is your last or the only will, may not themselves revoke the will. The simplest thing you could do is to kind of execute a new will, and then you will insert in it a revocation clause, which will state, for example, I revoke all my former wills and testamentary disposition and declare this to be my last will and my testament. Of course, this simple clause will revoke all previous wills and then codicils. So if you do this, you will have done what is needful to have revoke your earlier wills by making a subsequent will. So they say making a subsequent will expressly revoke the earlier will if you put in that new will a revocation clause by not merely stopping at stating that this is my last and only will. If you state this is my last and only will, it will not revoke the will expressly, but it will be revoked expressly if you go further to say that though it is my last and only will, but I revoke all former wills and testamentary disposition and declare this to be my last will and testament. And then, of course, this is the simplest way by which you can go about it. It is important that revocation clauses are drafted very correctly, and then to determine, to look at, to express or to explain this or further illustrate this, you can see the case of Lothrop Lutwidge and Lothrop Lutwidge. Lothrop is spelled Lowthorpe Lutwidge against Lothrop Lutwidge. Lothrop Lutwidge against Lothrop Lutwidge. Lothrop is spelled Lowthorpe Lutwidge. Lutwidge is spelled Lucwidge against Lothrop Lutwidge. Sir, so now.
Hello, sir. Hello.
Yes, sir. Yes, sir.
Sorry, sir. I was just going to. No. I was just going to make an observation on the revocation clause.
Yes, sir.
Because no particular reference was made to the former wills. I thought there should be something like, oh, my will dated this.
No,
my will dated.
That would be. Okay. No, that would be. It could be a surplusage. No rule says that You cannot put it the way you have put it. I get my point.
Okay, sir.
Hello?
Yes.
But by inference, if I say, yes, there's no law that says you cannot put it like that. But by inference, if I say, I revoke all former wills and testamentary disposition and declare that this to be my last will and testament. So what that means is that this one will be dated today. The other one will have dated yesterday or day before. So when I mention my former, so the one for yesterday and day for yesterday would naturally constitute former, and this one will be the only and the last will. So whether I put a date of yesterday there or date of day before yesterday there, it will not matter, because when they put the two side by side, you will see that this one is dated 18, the one of yesterday is dated 17, and the one of day before yesterday is dated 16. Is that not it? So in the same way, you will not be penalized. You will not be penalized if you say that I revoke my former wills and testamentary disposition dated 16th of December and 17th of December. I get my point, and I declare this to be my last. So whether you put it or you don't put it, there's no penalty for it. So, but the fact is that if the will is dated and is signed, it will show that it has, it has a priority over the ones that have been made earlier than now. So that is the point that I'm trying to make. That is the point I'm trying to make. So we said that it is important for us to put that simple clause, and that what is elucidating this is found in the case of Lothrop Lutwidge and against Lothrop Lutwidge, and that in that case, the issue was whether the testator had successfully revoked his former will. As revocation clause stated in the will is that, 1, I revoke all former wills, this being my last will and testament. It says that I revoke former will, this being my last will and testament. Are we together? So now the issue was that, has he truly revoked the earlier will? The court held that the opening words in this clause were essential in determining the testament, the testator's revocation. Should the opening words have simply stated, this is my last will and testament, it will have failed to be sufficient for an express revocation. Are we together? So what we are trying to say in essence is that there are two things that you must mention. One of them is most important, which is that you must state clearly that I revoke my former wills, and that you must, after having said that, you will now say, this is my last will and testament for it to be valid. In this case of Lothrop Lutwidge, if the guy has not mentioned, I revoke my former will, it will have been taken that this new will has not revoked the earlier will. Are we together? Are we together? Is that clear? Hello?
Yes, sir.
Okay.
Yes, sir. Yes, sir. Yes, sir.
So Langton J said that the earlier disposition were revoked because the burden of proving that the testator had intended to revoke them had been discharged due to the expression and the use of the word I revoke within the express clause within the will. So what I'm trying to say is that the word I revoke my former will is very crucial when you make a subsequent will. I want that will to supersede the one that I've made earlier on. So it is not sufficient for you to say that in this your new will or in this your subsequent will, that this is my last will and testament. You must have a revocation clause. You must have a revocation clause which states that I revoke my last will and testamentary disposition and declare this to be my last will and testament. However, see the case of Lothrop Lutwidge against Lothrop Lutwidge, where the man had simply mentioned that, simply mentioned that I revoke all my former wills, and court held that that was the saving grace for the man, and that has shown clear intention that he had wanted to do what he had wanted to revoke the will. So now, what's that? Oh, we're almost there. Okay. Do we still have class next week? Hello?
Hello, sir.
Do we have class next week?
Well,
no, sir. No, sir.
Okay.
No,
okay.
sir, we don't have.
Okay, please let everybody note where we have stopped. I wish you Merry Christmas and Happy New Year. And I hope that
Thank you,
when
sir.
we come back next year, we'll take it up from there. This is an assignment to everybody. Please note where we stop.
Okay, sir.
We stop at Lutwidge.
No, sir. No.
We stop at Lotop Lutwidge against Lotop Lutwidge. And then the take home for us in that Lotop Lutwidge and then Lotop Lutwidge is that your will, that is subsequent will, to revoke the earlier one must contain a revocation clause that is saying that you revoke all your former wills and old wills, and then you now make this one the new will and your last will. I wish all of you the very best.
Hello, sir.
Yes, sir. Yes, sir.
Thank you for wishing us a happy holiday, and thank you for putting us in holiday mood. But let me ask this question, sir. This revocation process or procedure, do we still need to follow the normal procedure of getting two witnesses to be present at the same time while doing this?
Certainly, because, yes, now they say it's a subsequent will now. It's a new will. Okay. It's a new will. Because as we go on in this lecture, yes, as it's a new will. So it's just like a new will which will revoke the earlier one. You follow the normal procedure. Okay. They will witness it. You still have to lodge it like you have lodged the first one, or do the normal means of preservation. However, take it through the normal means of preservation. However, what they are saying here is that there are times that when you write a new will, you may not have been able to revoke the earlier one if you don't put this express word there. Because what that means is that they will not be looking, because if you don't put that express word there, they will not be checking whether there's a conflict between the old one and the new one. It is in respect of, yes, it is if there's a conflict between the old one and new one that the new one will prevail. For example, you have dealt with a number of subjects, and then in the first one. And in the second one, you still dealt with some other subject, but you left out some subject in the second one that were dealt with in first one. For example, you dealt with like 10 subjects or 12 subjects in the first one. And then in your next will that you feel that you revoke the first one, where you have not mentioned that you revoke the first one, court will still put the first one side by side the second one. But if you have put that revocation clause, they have nothing to do with the earlier one. But if you didn't put the revocation clause, they will now have to put the old one and the new one side by side and check how many subjects did you deal with in the first one? How many subjects have you dealt in the second one? For example, in your first will, you dealt with 12 subjects, and your second will, you dealt with 10 subjects. Those two subjects that are there in the first will, which are not dealt with in the second will remain standing. They will remain valid. Then they will not check these 10 subjects against one. If for any reason there's a conflict between the way you have disposed your asset in the first will, and the way you have disposed your asset containing those 10 subjects in the second one, then the one in the new will prevail over it. All of that I would explain to you when we meet, when we converge again. So that is the point that you need to note about the revocation clause that must be contained in any subsequent will that you are making.
On behalf of the class, I wish you happy Christmas.
Thank you very much.
A Merry New Year.
Thank you so much. You are very welcome.
Thank you.
All right.